on this dark, wet evening. My name is Iola Solanki, and for the last 3.5 months, I have been the Jacques Delors Professor of European Union Law and a Fellow of Somerville College. So in other words, I am Steve's successor. And it's my privilege to introduce him this evening for the second instalment of these Clarendon lectures on sports, law and governance. So on Monday evening, at the first lecture, Steve gave us a riveting introduction to his topic. He categorized sports law in two ways, as internal and external. Introductions can also be so categorized. An external focus would speak about Steve's reputation as an unrivaled expert in European Union law, his work and development on European Union law as the holder of the Jacques Delors Professor in European law at Somerville College, his work previously as the Jean Monnet Chair of European Law at the University of Nottingham, his numerous publications in European Union law and in internal market law, and of course as a leading voice in the area of sports law and as the author of a pioneering textbook in that area, published by Oxford University Press in 2017. My introduction, and I have been instructed to keep it brief, will be internal. So I'll focus on Steve's approach to his academic work, as seen from within the law faculty and Somerville College. Some of you may remember the American sitcom, Everybody Hates Chris, based on the teenage years of comedian Chris Rock, he of the slap. The opposite is true of our esteemed speaker this evening. Everybody loves Steve. Colleagues at Somerville and in the law faculty have nothing but positive things to say about him. He is a rock star. He's described as a truly lovely guy, a wonderful diplomat, a terrific colleague, utterly dependable, cool and calm in all meetings, always wise, mischievous with a great twinkle, very serious, very serious, but with a great twinkle in his eyes. He was a team player, is a team player, supportive of colleagues and Somerville College, helping wherever he could, for example, with the dreaded admissions interviewing. As a professor, he was a dedicated supervisor to many research students, some of whom are here this evening, and also brought European Union law to life for undergraduate students. His lectures often involved a show and tell. So for lectures on free movement of goods, he would bring, for example, a bottle of cassis or some pasta, made, of course, from durum wheat. In short, he left some big shoes for me to step into. But I say this not to flatter or embarrass him, but to highlight that we can trust him to tell it like it is, with clarity, candor, care, and a big dose of mischievous humour, as we who attended on Monday can confirm. For the first episode in his Clarendon lectures, he incorporated personal photos, reflections, original entry tickets to various World Cup matches, as well as pictures of Putin and the Red Baron. He told us about his passion for football since childhood, which has lasted to this day. As a loyal supporter of Hull City and sometime editor of Hull City's bi-monthly football fanzine On Cloud 7, he has travelled far and wide to support his team and, of course, all over the world for the World Cup, the Euros, various Premiership games in his love of the beautiful game. So we are in for a special treat over the next hour or so to hear his thinking on judging, judges and sport. He ended the lecture on Monday with the tantalising idea that the public policy exception in the New York Convention might provide a chink through which to review the exceptional autonomy enjoyed by sports governing bodies. I'm looking forward to hearing about whether this public policy exception has ever been effectively used in this way. So, ladies and gentlemen, settle into your seats, and without further ado, please join me in welcoming back to the stage for his second Clarendon lecture, Steve Weatherill.
Well, thanks very much. So, on Monday, I was talking about how sports governing bodies typically make appeal to the need for autonomy. They make the claim that they should be entitled to decide how sport is structured and run according to their own terms, without supervision from the outside, by the law of states, the law of the European Union, and other international organisations. And you know, sports governing bodies have a point when they make that claim. Sports governing bodies have expertise in understanding what their sport needs, which is typically superior from that which you could expect from judges. Also, there's a pretty good argument that sport needs transnational, indeed global rules, which are generated by global sports governing bodies, and that sports practices should not be fragmented along national lines by jurisdictional variation between state laws. So sports governing bodies have a point when they appeal to the need for autonomy from legal supervision. And in practice, they achieve that autonomy to a considerable degree by the commitment to solve disputes through arbitration, which is written into the constitutions of most sports governing bodies. So most sporting disputes are resolved through arbitration, ultimately by the Court of Arbitration for Sport. They're kept in-house. And the New York Convention guarantees that insofar as an arbitral award is challenged before a national court, then it shall be upheld. There's a strong pro-enforcement bias in the New York Convention in favour of arbitration. But, as I already suggested on Monday, and as Iola has mentioned already, we need to be sceptical about this claim to autonomy. It has virtues, but it also has vices. The claim to autonomy might be simply a way to protect power, to promote self-interest. And in particular, where public policy is at stake, we need to be sceptical about the claim of sports governing bodies to be able to do it on their own. So there are limits to arbitral finality. There are limits to the autonomy enjoyed by the Court of Arbitration for Sport, which means, in turn, that there is room for the application to sport of what are called external sports law, state law, the law of international organisations, such as the European Union. Some disputes simply fall outside the jurisdiction of the CAS, those involving third-party broadcasters or sponsors. Disputes between governing bodies and such sponsors and broadcasters are simply dealt with through the ordinary courts, litigation. But even when a matter falls within the scope of the New York Convention, even when the matter falls within the jurisdiction of the CAS as a sporting dispute, it is explicitly provided in the New York Convention that there's a public policy exception. So a court invited to enforce an arbitral award should not do so if that arbitral award offends against public policy. Exactly what public policy means would depend on a survey of the practice of courts worldwide. I'm not going to do that. I'm going to concentrate on the European Union, in part because it's one rather rich case study, but also because it is a particularly important case study. The EU's reach is very wide. It has 27 member states, and as I'm going to explain, the implications of European Union law extend beyond the borders of those 27 member states. As far as the European Union is concerned, there are limits to the autonomy which it will grant to CAS under the name of public policy. In Mecca, Medina and Maichen against the Commission, a case that I'll be saying more about later, swimmers had been found guilty of doping offences and had been suspended for 2 years. And that was a decision, the suspension, which had been confirmed by the CAS. So the matter had been resolved through the processes foreseen by the sporting dispute resolution mechanisms. The complaint in the case, which reached the European Court of Justice, was that the doping sanctions violated EU competition law. The court, as I will explain, decided that they did not violate EU competition law, but at no stage did the court consider itself barred from discussing and examining the matter because there was a Cass ruling in the background. Rather, the Court of Justice assumed that if there were a matter of EU competition law at stake, then that would be a sufficient reason to set aside the Cass's arbitral award and to insist instead on the application of EU law. So when public policy is at stake, competition law in this case, arbitral finality comes second, the application of external sports law, the EU's rules on competition, comes first. So sporting autonomy must yield. The same approach applies before national courts of the member states of the European Union. The Eco-Suisse decision of the Court of Justice is not about sport, but it is about arbitration. And in the Eco-Suisse case, the Court of Justice held that if an arbitral award is contaminated by the perpetuation of an anti-competitive practice, then that arbitral award shall not be enforced by a national court in a member state of the European Union. So again, public policy, as understood by the European Union, is a sufficiently strong reason to set aside an arbitral award. Sporting autonomy is subordinate to the importance of the EU rules on competition. So, the sporting autonomy of which I spoke on Monday has its limits, and those limits are reached where public policy is at stake in the arbitral process. Specialists in arbitration will be critical of this approach, are critical of this approach. They will tell you that the European Union has a relatively wide understanding of public policy. It's relatively intolerant of sporting autonomy. It undermines, arbitration specialists will say, the finality and therefore the attraction of arbitration. But the Court of Justice has ruled clearly that the lex sportiva, the practices we find within sport, must comply with European Union law, where the European Union law at stake counts as public policy. What is public policy under EU law? That's the list. It's not a list which is written in any legislative text, but that's the list which I deduce from the case law of the Court of Justice. EU public policy covers these fundamental aspects of EU law. The free movement of workers and of services across borders. Competition law, otherwise known as antitrust law. Articles 101 on anti-competitive bilateral and multilateral practices, and Article 102, unilateral practices pursued by a dominant undertaking, an undertaking in a monopoly position, to use the English terminology. Public policy under EU law also covers non-discrimination on grounds of nationality and certain other horizontally applicable fundamental rights. The point then is that arbitral awards must comply with those requirements of EU law. Sporting practices more generally must comply with those requirements of EU law if they are to be enforceable within the European Union. So what this stands for is the intersection of the two types of sports law, which I explained on Monday. The existence of the CAS, the dispute resolution procedures foreseen by sport, internal sports law, does not preclude the development of external sports law. Here, the European Union's demands. What it means, where public policy is at stake, sports governing bodies may not simply insist on the autonomy of their decision-making processes. They must instead, public policies at stake, seek to defend their practices insofar as they come into conflict with European Union law. So the key conflict, the key tension, is whether sporting autonomy can survive review in the name of European Union law. And that we can only understand by inspecting the case law. So here's a summary. The European Union grants no absolute autonomy to sport. There's no pure sporting exception. But sensitivity to sport's special features is captured in Article 165 of the Treaty on the Functioning of the European Union, which provides that the Union shall contribute to the promotion of European sporting issues while taking account of the specific nature of sport. Whatever that means, Article 165 is really a codification of the Court's long-standing interpretation of EU free movement law and competition law, case law, which largely predates the entry into force of Article 165, which was added to the treaty only as late as 2009. So it's to that case law that we must turn to understand how European Union law assesses sporting practices when they fall subject to review by its courts, which, to repeat, to underline, doesn't happen often. Most sporting disputes are resolved in-house through the arbitral process, but sometimes, just sometimes, especially where public policy is at stake, the courts of the European Union review sporting practices. Probably the greatest case of all in European Union sports law is Bosman. It's a free movement case. Bosman was a footballer. He wished to move from his employer, a Belgian club, to his new employer, a French club. His contract of employment had come to an end. If this was a university lecturer or a sausage maker or a seller of financial services, you would simply move at the end of your contract from one employer to another one. Not so in football. In football, the transfer system dictates that the selling club must be satisfied with the terms offered by the buying club, which generally involves payment of a transfer fee to secure the transfer of the player's registration so that the player can play for the new club. So in football, uniquely, player mobility involves not simply contract law, but also the transfer regulations which are enforced within the game by FIFA and within Europe by UEFA, collectively agreed terms which govern the movement of players. So the question in the Bosman case was whether that transfer system, which limited Bosman's ability to pick his new employer, was compatible with the EU free movement law. Here's what the court had to say. In Bosman, in the key paragraph in Bosman, which sets out the court's understanding of the sporting concerns which underpin the transfer system, the court says, in view of the considerable social importance of sporting activities, and in particular football in the Union, the aims of maintaining a balance between clubs by preserving a certain degree of equality and uncertainty as to results, and of encouraging the recruitment and training of young players must be accepted as legitimate. Where does the court get that from? It certainly doesn't get it from the treaty. The treaty at the time didn't even mention sport. It didn't get it from any legislative text either. There were no such legislative texts. What the court's trying to do there is to interpret EU free movement law in the particular context in which it arises, which is sport, which is football, which is the transfer system. So this is the Court of Justice creatively developing internal market law in a context-specific manner. What the court concluded then was that a transfer fee does meet legitimate objectives within football. The transfer fee most obviously encourages clubs to train up young players in the expectation that they'll be able to reap the rewards of their success when they're transferred later on. In the Bosman case itself, the court decided that a transfer fee was justified, but not the one which applied in football at the time. The court objected to the application of a transfer system, even to players out of contract. That went too far. So the Court of Justice's ruling was that a transfer fee for in-contract players would be lawful. The transfer system, which applied at the time, even to out-of-contract players, was not lawful. So the transfer system was changed. It was modified to eliminate its application to out-of-contract players, but it lives on in application to in-contract players. It has important consequences for the way in which the market for footballers operates. A player coming to the end of his or her contract knows that if he or she runs the contract down and it expires, then he or she can simply choose another employer, a way in which a sausage maker or a university lecturer would. No transfer fee is payable, and the player can expect to receive increased wages as a result of the money that would have been paid in the transfer fee now being available to the player. By contrast, the clubs know that they must do their best to offer attractive terms to keep the player in contract, so that they maintain access to his or her services, but also so that in the event that the player is transferred, they get a fee. The player who moves once the contract's expired is known as moving on a Bosman in the football industry, but the contract renegotiation that goes on behind the scenes is all affected by the Court of Justice's decision. In Bosman, contract renegotiation operates in the shadow of European Union law as interpreted by the Court of Justice. There's also a Brussels effect here. Once the transfer system had been modified for Europe, it made no sense to leave it unchanged for the rest of the world. Sport needs global rules, it needs a global transfer system. So FIFA changed the transfer system globally to comply with the Court of Justice's ruling in Bosman. So in this way, European Union law had an extraterritorial effect, the Brussels effect. Is the anti-doping case which I mentioned earlier. This is not a free movement case, it's a competition law case. And the question in the case was whether the doping ban, confirmed by a CAS ruling, contravened EU competition law by excluding the athletes from the market for sports services for 2 years. As in Bosman, so in Mecca Medina, the Court of Justice interpreted EU law in the context in which it applied. The Court of Justice was willing, it was receptive to the particular sporting considerations which informed the anti-doping system. So, the Court of Justice explained that they, the anti-doping procedures and sanctions, do not necessarily constitute a restriction of competition within the meaning of Article 101, since they're justified by a legitimate objective. Such a limitation is inherent in the organisation and proper conduct of competitive sport, and its very purpose is to ensure healthy rivalry between athletes. Again, where does the court get that from? It doesn't get it from the treaty, it doesn't get it from any legislative text, it gets it from its own understanding of the need to mediate between the orthodox demands of EU internal market law, on the one hand, and the specific expectations of the organisation of sport on the other. This is applied internal market law. Those of you who know internal market law will be familiar with the court's famous decision in Cassis de Dijon, which stands for the court moving beyond the textual limitations of the treaty and devising a supple public interest test for determining when a restriction to cross-border trade may be justified or not. That's all that's going on here in Bosman and in Mecca Medina, interpreting EU internal market law in a way that is sensitive to the particular context in which it arises and is applied. Albeit that here, in relation to sport, it's private interests that are at stake, as opposed to the public interests such as environmental protection, consumer protection, which were at stake in Cassis de Dijon and the many cases which have followed it. Bosman was about free movement. Mecca Medina was about competition law. In practice, almost all the sports cases of recent years have been decided in the light of competition law, not free movement. Competition law has two pillars to it. Article 101, which condemns anti-competitive practices of a bilateral or multilateral nature. Article 102, which condemns abusive practices by a dominant undertaking which monopolises the market. In principle, sporting practices with economic effects are subject to EU competition law, just as practices with economic effects in any sector are subject to EU competition law. In principle, sport's not special. But the thematic tension that runs through the case law asks whether in some circumstances, as we saw in Mecca Medina, sport may, after a contextual examination of the practices under attack, be treated as special. Sometimes it will be, sometimes it won't. Typically, sports governing bodies will overclaim how special their practices are, and the job of the court will be to rule on whether their claims are convincing or not. Let's take a look at some examples. Sometimes sporting practices are held to be unlawful, according to an entirely orthodox analysis, which pays no attention to the fact that the practice happens to arise in sport. Back to Monday. The World Cup in 1998 in France involved the selling of tickets by the organisers on a basis which favoured French nationals and residents. So when I went to the World Cup in France in 1998 and tried to buy tickets, I had to buy them from French nationals and residents who had been ahead of me in the queue. There's my ticket for Spain-Nigeria, initially issued to Mr. Samson. That's unlawful under European Union law. You cannot discriminate on the basis of nationality in the selling of goods and services. That discrimination happened to occur in sport was of no significance at all. If you try and sell sausages or financial services and discriminate on the basis of nationality, you will be in breach of EU law. The fact that it happens to be access to a football stadium makes no difference. Sport's not special. Here's another example drawn from United Kingdom competition law, which in all material respects runs parallel to EU competition law, so exactly the same approach can be expected. Recently, it was concluded by the UK Competition and Markets Authority that certain sports shops and one particular football club, Glasgow Rangers, had been colluding to fix prices on the sales of replica shirts. That's unlawful. Price fixing is the most pernicious of all anti-competitive practices. It pushes prices up to the detriment of the consumer. Did it matter that this happened to arise in relation to sports goods? Not in the slightest. Fix prices on sausages and you will be acting unlawfully. Fix prices on football shirts, you're acting unlawfully. Sport is not special. Sometimes sporting practices are lawful. But according to an analysis which doesn't lay emphasis on the particular sporting context which arises. Champions League. Wherever you watch a Champions League match, it looks the same. Whether you're in the stadium or whether you're watching on television, it's the same logo everywhere across all the 51 members of UEFA. It's the same bombastic, pompous anthem everywhere. Other people don't realise just how banal the lyrics are. There they are for you. I could hum it, I could sing it, I'll do neither. Why is it the same everywhere? The reason it's the same everywhere is that UEFA is the sole seller of rights to broadcast the Champions League. You can't go and buy coverage of a Champions League match from an individual club nor from an individual national football federation. UEFA is the sole source of supply. It's a joint selling arrangement. UEFA sells the rights to the whole package of Champions League matches covering the whole continent. That's a restriction of competition. Yeah? If you could go and buy rights from individual clubs, then there would be competition on terms of supply, on price, and that would doubtless keep the price lower than it otherwise would be. So it's a restriction on competition against which Article 101 of the treaty is directed. But the Commission, inquiring into the compatibility of the Champions League deal with EU law, concluded that there were significant economic benefits from allocating to UEFA the sole rights to sell, particularly the reduction of transaction costs. If you buy from UEFA alone, you don't have to deal with multiple sellers in different countries with different legal regimes and different cultures. A single point of selling can reduce costs. The Commission was also impressed by the advantages of branding as a means to encourage consumer appeal. Consumers are, it seems, attracted by the existence of a single brand applicable to the whole tournament, rather than it being fragmented between different national approaches. So the Commission concluded that there were economic benefits to this restriction of competition. The Commission did insist that broadcasting rights contracts should last no more than 3 years, so as to provide the opportunity for new broadcasters to enter the market periodically. But at bottom, the Commission considered that the economic benefits of the deal outweighed the restrictive effect on competition. That's not sports-specific. There's nothing special about that being a sports deal. Any joint selling arrangement which, in short, adds value to the product or service would be treated in exactly the same way. Again, in this case, sport was the context in which the Commission inquired into the application of EU competition law, but there was no sport-specific reason for deciding the decision in a way differently from that which would have applied in a normal market. Sometimes sport is special. And the two circumstances in which sport is special are, first of all, in regard to a tolerance of coordination that one permits in sport that one would not permit elsewhere. Secondly, a suspicion of regulatory power that arises in sport that would not arise elsewhere. Let me deal first of all with tolerance of coordination, where sport is special. If you're a sausage maker, your wildest dream is to be the only sausage maker in the world. If anybody wants to buy sausages, they come to you. You can price accordingly. You can do very well. You don't want competitors. If you're the only football club in the world, nobody wants to watch you. Nobody cares. Football clubs need rivals. They need credible rivals. So there is an interdependence between participants in a professional sports league which you do not find in a normal market for sausages, for beer, for financial services. So coordination is what happens in sports leagues. In most areas of competition law, we're very suspicious of coordination. Now, exactly how deep, how intense the coordination is in sports leagues depends on the particular model which is pursued. If you look at North America, you see extremely vigorous forms of coordination in sport. So there are draft picks, there are aggressive salary caps. The point is to ensure a coordination which evens the playing field so that every club in the league has, at least in the medium term, a credible likelihood of winning the thing. Sometimes times it's remarked on just how socialist North American sport looks. This willingness to equalise, this willingness to share distribution, but it's not socialist at all. It's aggressively capitalist. The insight is that only if every team has some chance at some time to win the league will the league be attractive to consumers. The North American assumption is that promoting competitive balance through draft picks, through salary picks, is what makes the market work. So what look like restrictions on competition, salary caps, are pro-competitive and make the league attractive. In Europe, we're much less wedded to competitive balance. I'll say a bit about financial fair play in a while, which is the area in which Europe is starting to mimic American patterns. But in Europe, it's certainly true that the intensity of coordination is less strong than in North America. But the basic insight still runs in common. There is an interdependence between competitors in a sports league. Whatever detailed form that may take, we accept a tolerance of coordination in sporting activity, reflecting the interdependence of competitors and the need for a credible competition, which you would not find in other economic sectors. Indeed, this need for coordination is why we have governing bodies in sport in the first place. It's been known for 100 and more years that you need to have a governing body to make the key decisions which apply in common to all participants in the sport. So this tolerance of coordination as a feature of professional sports leagues must then affect the legal analysis, whether particular practices contravene competition law or not. The first decision of the Commission in this vein was concerned with UEFA's ban on multiple ownership of football clubs. So that you can have a controlling interest in one club, but no more than one. You just would not get that in a normal market. We don't care about sausage makers taking each other over. Okay? We don't care about financial services providers joining together, as long as they don't cross the thresholds for market dominance expressed through merger law. In sport, it's different. In sport, there is a prohibition against ownership of more than one club. That is reflective of the need for credible competition. Were clubs owned by the same person, there would be a whiff of match fixing. Nobody would be convinced that it was a genuine sporting competition. So there needs to be coordination to ensure there is a credible competition. And that coordination here takes the form of prohibiting multiple ownership. But lawful as an expression of a restriction within sporting competition which you just wouldn't find elsewhere. Sports special in relation to the interdependence of participants. Financial fair play. This is a set of rules introduced by UEFA, the European governing body for football, a few years ago. It's very detailed, but in short, it imposes a break-even requirement on football clubs. Clubs shall not spend more than they earn. Sometimes it's expressed as a prohibition against financial doping. The legal question is whether that's an expression of the need for coordination between clubs, or whether it's an anti-competitive suppression of spending. The European Court of Justice has never ruled on the point. At the time the financial fair play rules were introduced, there was an agreement expressed between the EU Competition Commissioner and the President of the UEFA in which they expressed themselves satisfied that the financial fair play rules were needed in sport and were compatible with EU law. But that's not formally binding. The CAS in the Galatasaray decision considered whether it believed that the financial fair play rules were compatible with law, and it thought they were. But that's not binding either. I think the financial fair play rules are probably lawful under EU law. The issue is this. In a normal industry, we would not have ex-ante rules on who can spend what. In a normal industry, we assume that if somebody spends too much, if a company spends too much, they go bankrupt. We lose them from the market. Good. Goodbye. You failed. Not a problem. We don't control spending in advance by sausage makers. We just expect the bankruptcy laws to get rid of the bad sausage makers after the fact. So the question here must be, is sport special? Is there some particular reason in sport, in football, why we need to control spending in advance and not simply leave the matter of overspending to be disciplined by bankruptcy after the fact? Well, I think there is. Sometimes it's said that we can't just let our great football clubs go bankrupt. That's not a good justification for financial fair play, because actually that problem's already addressed in football. Our great clubs don't go bankrupt. The companies to which they're associated go bankrupt. But the club lives on, usually under another corporate form, and sometimes after suffering the penalty of relegation or deduction of points. It's happened to Glasgow Rangers, it's happened to Fiorentina, it's happened to plenty of other clubs. But when that happens, when the great club or the lesser club goes bankrupt, they've already won their trophies. They've already denied the clubs that spent prudently their silverware. They've denied them their open-top bus tour. They've denied their fans their night on the town. That, I think, is the reason for financial fair play to be treated as justified under EU law. We need controls on spending which apply in advance to make the competition credible, to ensure that the real winners are duly rewarded in the way in which they should be. So again, interdependence and the need for a credible competition seems to me to mean that in this context, sport is special, and financial fair play as a control on spending in advance is justified in sport where it wouldn't be elsewhere. The tolerance of coordination as a reflection of the interdependence of participants in a sports league is an instance where sport is special and where the competition rules are softened in response to the special claims of sport to need to coordinate. When I look at suspicion of regulatory power, we're dealing again with a set of circumstances in which sport is special, but here the assessment goes in exactly the opposite direction. Here we are likely to be more critical of sporting practices from the perspective of competition law than we would be in a normal industry. Well, what we're dealing with here is Article 102 of the Treaty on the Functioning of the European Union, which prohibits the abuse of a dominant position. So where you've got an economic operator that dominates the market, they are subject to the prohibition against abuse of that powerful position contained in Article 102. Now, in most markets, Article 102 doesn't have a role to play because most markets are competitive. You don't regularly find a market where a firm is dominant. By contrast, in sport, market dominance is absolutely normal. Indeed, market dominance is a structural feature of the pyramid model of sporting organisation. That's how sports are structured. That's how football is structured. According to a pyramid model of governance, which has FIFA at the top as the rule maker, and the rules percolate down through the continental federations to the national football associations, which apply FIFA's rules in their competitions. The whole point of that system is to have a single dominant regulator. FIFA and have competitors, FIFA sets the rules for the global game. And within each national association, there's one federation which applies the rules. The holding a dominant position is absolutely the norm in sport. And that's been true for 100 years and more. The problems have arisen more recently as sport has become ever more commercialised. What's happened in sport is that it has become big business, sale of broadcasting rights, sale of sponsorship rights, sale of tickets, and so on. What's happened is that incrementally governing bodies, originally responsible for setting the rules of the game, have also taken on commercial responsibilities, extremely lucrative ones. So what we have under this pyramid system is a wrapping up of regulatory functions and commercial opportunities in the same entities, FIFA and its allies at continental and at national level. For example, the World Cup used to comprise 16 countries. That was increased to 24. There'll be 32 playing next week, and there'll be 48 in 4 years' time. Is that expansion because of the sporting need for more games, or because of the commercial interest of FIFA in generating more games and more revenue? It's doubtless both. And that's the point. Regulatory motivations are wrapped up with commercial aspirations. So these governing bodies have enormous regulatory power, which brings with it commercial opportunities for them. So our suspicion of regulatory power should be particularly salient when sports governing bodies use their regulatory power to achieve commercial advantage where there's a conflict of interest, where the sports governing body's rule-making choices also have direct commercial consequences for its own position. The Court of Justice of the European Union has addressed this issue on a couple of occasions. The first one was the Moto case, which arises in an extremely esoteric context. It concerns motorcycling in Greece. There was a Greek motorcycling federation. It was the only Greek motorcycling federation. That's the nature of the beast. And the Greek motorcycling federation's job, among other things, was to decide which motorcycling events should be authorised for Greece and which should not. The problem that generated the litigation in Moto was that the Greek Motorcycling Association was very quick to authorise events which it promoted and from which it benefited, and very slow to authorise events which third parties wished to stage. It seemed pretty clear that the Greek Motorcycling Association was using its regulatory power to achieve commercial advantage. Here's what the Court of Justice had to say about this. First of all, the Court of Justice did not object to the existence of a single federation for the territory. The Court did not object to a sports federation having a gatekeeping role. What it did object to was the way in which this gatekeeping role was discharged. In particular, the Court said Article 102 precludes a national rule which confers on a legal person which organises motorcycling events and enters into sponsorship, advertising and insurance contracts the power to give consent to applications for authorisation to organise such competitions without that power being made subject to restrictions, obligations and review. So yes to a power of the sporting federation to authorise events, but only provided the conditions on which authorisation is made are transparent, non-discriminatory, subject to review. So what the Court's trying to do there is to limit the capacity of regulatory power to generate conflicts of interest, commercial advantages for the federation itself. In the same vein, The Commission decided the International Skating Union case in 2017, and its decision was, in almost all respects, upheld by the General Court in December 2020. This was another case involving a sports governing body, here in skating, faced with a third-party organiser which wished to put on skating events which would compete with those promoted by the International Skating Union. What the Skating Union did was to threaten skaters who were considering participating in the third-party events with expulsion from its own competitions, and in particular, the Skating Union threatened to exclude skaters from the Olympic Games if they chose to participate in competing events. And the Skating Union was the monopoly provider of access to the Olympic Games in this sport. The court, following the Commission, adopted the reasoning it had used in the Moto case. It decided that there was a legitimate need for a regulatory authority in sport to act as gatekeeper, to decide which events should be authorised and which should not. And the General Court went further to say that the protection of the integrity of the sport constitutes a legitimate objective. Very much generous from the perspective of the governing body. They do have a legitimate objective in protecting the integrity of their sport. But, as in the Moto case, it depends how that power is used. The General Court said it's appropriate in particular to examine whether the restrictions in question are inherent in the pursuit of those objectives and proportionate to those objectives. And it made clear that the aggressive way in which the Skating Union has sought to protect its interests at the expense of skaters and at the expense of third-party organisers went too far, was unlawful, and was therefore an abusive exploitation of the regulatory power enjoyed by the sporting body. That's EU sports law through the cases. Article 165, which I mentioned earlier, says that the Union shall contribute to the promotion of European sporting issues while taking account of the specific nature of sport. The Court's case law reflects that. Sport enjoys a conditional autonomy under EU law, which is to say sport is entitled to make autonomous choices about how to organise its sport on condition that it can demonstrate a need for those practices in the light of European Union law. So the court in Bosman did approve a transfer system, but not the extreme one at stake in the case. The court in Maker Medina did accept the need for anti-doping sanctions. And in both Moto and the International Skating Union decision, the court accepted the importance of a gatekeeping function exercised by sports governing bodies over events. Didn't agree with the way in which that power had been exercised. I think there's a kind of sporting margin of appreciation here, whereby the court does allow sporting practices to be pursued unless the conditions which attach to them are so egregiously aggressive or abusive as to call for condemnation. This is what I think sports law's all about. Judging whether sports governing bodies have got good arguments that they're special or bad arguments, and what may be the implications. So the intellectual heart of sports law is distinguishing between self-interested pleading for autonomy and instances where sport is genuinely special. Sports law is not just about getting a bit of law here and there and saying, oh, that happens to apply to sport. It's much more, I think, intellectually ambitious than that. It's tied together by this need to appreciate just how strong the argument for sporting autonomy might be when particular practices which come into conflict with legal rules, whether in states or in the European Union. And there's more to come. There Let me finish with the European Super League, though the European Super League is not finished with us. 18 months ago, 12 clubs announced that they were going to create a new venture, a European Super League. That's what the BBC had to say at the time. 12 of Europe's leading football clubs have agreed to create a Super League. The European Super League said the founding clubs had agreed to establish a new midweek competition, with teams continuing to compete in their respective national leagues, but not in the Champions League, which is the competition which UEFA runs for these powerful clubs. What's really at stake here was that these 12 clubs were proposing to create a European Super League which would be a direct competitor to UEFA's Champions League, which has traditionally generated the champion club in Europe. Under the original proposals, which were unveiled in April of last year, the original 12 clubs were guaranteed access to the European Super League. There was no question of them having to qualify. They would be in it from the start. More than that, they would be protected from the risk of relegation for a period of years after the founding of the competition. There's the dirty dozen. 6 English, 3 Spanish, 3 Italian. Many of the most successful clubs in the history of European football, and Arsenal and Spurs. Some powerhouses there, but if you were picking the 12 best European clubs ever, you wouldn't pick that 12. Think about the great heavyweight clubs that are missing. What? These clubs, between them, 10 times the champions of Europe, were not even invited to the party. Two days later, protests were intense. 2 days later, Arsenal apologised in an open letter to their fans and said they had made a mistake, adding they were withdrawing after listening to supporters and the wider football community. Sincerity drips. Tottenham chairman Daniel Levy said the club regretted the anxiety and upset caused by the proposal. Okay. UEFA's stance on this was that the European Super League harmed their model of sports. UEFA insists that its competitions are run on the basis of merit-based qualification, which is missing in the European Super League. Also, promotion and relegation is the norm in European football competitions. It's not present in the European Super League, at least not for the Big 12. And UEFA put in place a system to impose sanctions on any future resuscitation of this venture, thereby to deter any possible reinvention of the European Super League. Most of the clubs, most of the 12 have withdrawn, but not all of them. The European Super League company lives on, and it brought a case before a court in Madrid complaining that UEFA's response to the Super League contravened European Union competition law. Specifically, what the clubs argued was that UEFA was seeking to suppress competition. UEFA was seeking to suppress the emergence of a new product on the market for football competitions. And the breakaway club said, look, all we're trying to do is offer consumers a choice. And isn't that, the clubs say, exactly what EU competition law is designed to achieve? UEFA's response is to insist, using the terminology adopted by the General Court in the skating case, that it, UEFA, is seeking to defend the integrity of sporting competition. It's seeking to protect a model whereby there is one competition which generates the champion of Europe. And that, moreover, there is, according to UEFA, a need for promotion and relegation to validate the integrity of sporting competition. This is pretty intriguing. The case is pending before the Court of Justice in Luxembourg. We expect an opinion of the Advocate General next month. We expect a decision of the court sometime in the first half of next year. It's really interesting because it really is at the thematic heart of sports law. The clubs are on pretty solid ground if one understands this as a matter of orthodox competition law. The clubs are arguing for more competition. But if we consider this to be a sport-specific case, then UEFA is the party that has the stronger hand. They are seeking to defend the integrity of the existing competitive structure of European football. It's really difficult to decide who wins. It's unpredictable too. What's at stake? In the questions which the Court of Justice has been asked is there a European model of sport? And legally there isn't. There's certainly no European model of sport defined by European Union law. What the European model of sport is a rather loose description of the collection of practices that make up the organisation of football in Europe. The Let's Sportiva. Is defensively compatible with EU law? If so, in what ways and with what limits? Well, we don't know. It's necessary to litigate to find out. Very unstable, very unpredictable state of affairs. And even when the Court of Justice rules, all it will be doing will be applying competition law to the particular dispute which has arisen. In no sense will the Court of Justice be providing a comprehensive mandate according to which we might be able to understand what the European model of sport is and how far it may be defended. The case law of the court, absolutely fascinating, in many ways very impressive, as the court seeks to mediate the tensions between the orthodox expectations of internal market law on the one hand, and the desire of sports governing bodies to show that their practices have sporting specificity and should be respected as a means to protect the integrity of sport. But it's not a very predictable basis for deciding how to operate in this market. Ultimately, EU intervention is typically reactive, unsystematic, ad hoc. A bit of transfer system here, a bit of anti-doping there, a bit of Greek motorcycling on the side. EU law operates only according to the limited assumptions of free movement law and competition law. It doesn't set broader ground rules, and it certainly doesn't get into issues associated with governance, equality, representation, accountability. So should it do more? Should the EU make sport better? Should someone make sport better? Tomorrow.